If it pleases the court, my name is Lachlan McLennan, and I appear on behalf of Marshall Ike, the defendant. Your Honour, I submit this application regarding the evidence against Mr. Ike under Section 590AA subsection 2E of the Criminal Code. I contend that the admissions of Mr. Ike be inadmissible as evidence, subject to the court's discretion and Section 130 of the Evidence Act. My client has been charged with 84 counts of breaking and entering and 1 count of stealing. At all relevant times in this case, Mr. Ike was 14 years of age, yet despite this, he has been denied procedural fairness by police officers at every turn. There has been no regard for Mr. Ike's statutory entitlements, age, or cultural background. I first submit that there has been a failure to comply with the special requirements for questioning in Division 3 of the Police Powers and Responsibilities Act. For this reason, I submit that the evidence should be excluded, as per the public policy factors established in Bunning and Cross. As a 14-year-old, Mr. Ike is evidently a child, and as such, any question by the police is subject to the provisions of Section 421 of the Police Powers and Responsibilities Act. This section entitled my client to speak to a support person of his choosing. Despite this, he was denied the ability to choose a support person. Mr. Ike had not met his support person before the interview, let alone chosen them. This demonstrates a clear breach of Section 421, subsection A. Secondly, I submit that on 2 separate occasions, the officers interviewing Mr. Ike failed to properly caution him, subject to the requirements of Section 431 of the Police Powers and Responsibilities Act. My client was interviewed in an impromptu manner in the police car on the way to the station, as well as more formally at the police station. His responses in these interviews formed the basis of the allegations against him, and yet neither time was he informed of his basic right to silence. Informing the subject of an interview of their right to silence is a requirement of Section 26 of the Responsibilities Code of the Police Powers and Responsibilities Act, and yet my client was not just left in the dark, he was actively misled by his support person. In his interview at the police station, my client, who as a child is young and impressionable, was told that he should answer all of the questions asked by police. There has been a clear disregard for the procedures Mr. Ike should have been afforded at law. Furthermore, I submit that the requirements of Section 418 of the Police Powers and Responsibilities Act were not afforded to my client. Section 418, subsection 1, provides the right to communicate with a friend, relative, or lawyer prior to the questioning, yet at no time was Mr. Ike informed of this right or allowed to exercise it. As such, not only was he denied the opportunity to speak to a support person of his choosing for the police interview, he was also not able to speak to a friend, relative, or legal representative. Your Honour, I contend that at every stage of the investigation against my client, corners were cut and procedural justice was denied. For this reason, I submit that the court exercise its discretion established in the Queen and Ireland to exclude the evidence against my client. Firstly, as per the established factors set out in Bunning and Cross, the breaches against my client are too numerous to constitute mere mistake. There was also no pressing circumstance or situation to secure a confession from Mr. Ike. The police simply cut corner after corner, to the extent that the interview itself does not appear to have been recorded properly. Large sections of the interview are inaudible, which constitutes a failure to comply with Section 436 of the Police Powers and Responsibilities Act. The charges against my client are also relatively minor in nature, and additionally, these procedural breaches are also breaches of statute. The very purpose of the Police Powers and Responsibilities Act is to ensure fairness and protect the rights of those who are subject to the powers of the police. Here, the breaches of my client not only denied him procedural fairness, but also struck at the very purpose of the legislation designed to promote fairness, understanding, and consistency in the application of police powers. I submit that to allow this evidence would establish a dangerous precedent and undermine public confidence in the administration of justice. It is also worth noting that the officers conducting the interview showed little regard for well-established cultural procedures. In the police car, when passing by some 84 properties, my client was asked closed questions designed to elicit a yes or no response. It is well known that such questions can result in gratuitous concurrence from the suspect as they attempt to give the interviewer the answers they are looking for. I contend that the answers given by my client did not represent his actions and were merely a means of keeping an intimidating police officer satisfied. For this reason, I submit that the interview of Mr. Ike be excluded under the fairness discretion established in the Queen and Christie. The direct questioning tactic used by the police led to gratuitous concurrence, and this has been held to have diminished the probative value of evidence in several Australian cases, including Hall and Police, and the Queen and Anunga. The persistent procedural breaches prejudice my client in this case and the interests of justice. The police have made no attempt to conform to the basic requirements of the Police Powers and Responsibilities Act. In addition to an inaudible confession, my client has been denied the opportunity to choose a support person, was not informed of his basic right to silence, and has not been given the option to communicate with a friend, relative, or legal representative. There have been flagrant breaches of well-established policy at every turn in this case. And for this reason, I submit that the evidence should not be submitted. That concludes my submissions to the court.